this would perhaps be the only time when introduction follows the future. Lynn has already talked about the future, so now I'm going to introduce the licensing business and talk about the licensing business. Now, before I go on to getting into the details of licensing, a couple of words that we need to understand. I would not endeavor to educate anybody here on those words because those are very commonly used words in the trademarks side. First, what is a trademark? Everybody knows what a trademark is. It's a mark which is capable of representation, graphical representation, and distinguishing the goods and services of one person from those of others. That's the basis that we will go with. And a mark per se could include a word, device, label, name, combination of colors, letters, numerals, etc. What is branding? Now, branding was the topic for the evening. So, I have tried to do something on branding and franchising and not go away from there really. The term branding is not defined in the Trademarks Act. However, I have tried and attempted to kind of give a sense of what the word actually means. It's a process by which name or identity of a company or enterprise is communicated, the promotion of a particular product or a company by advertising or distinctive design, which aims to create customer loyalty and attract more consumers. Then we go on to the third word, which is franchising. Again, franchising, the word per se is not defined. But what is defined in the Act, which is the Trademarks Act, is the word permitted use. It is given in section 2(1)(r) of the Trademarks Act. There are basically two main types of franchise. One is a product distribution franchise, which is like a supplier-distributor agreement. Example is like the Coca-Cola company. And the other is a business format franchise. The franchisee not only distributes the franchisor's products, but also uses the franchisor's format and procedure for conducting business. Bottom line, the franchisor retains ownership of the trademark and agrees to the use of those trademarks by the licensee for a fee, which is called the royalty or the license fee. Now, I already see yawning faces. That's only because introduction comes after the future. So, again, franchise and the characteristics, basic characteristics of a franchise. A franchise agreement is based upon a contractual relationship. Now, because there is no law governing franchises, what controls a franchise agreement is a contract itself. So, contractual relationship has to be honored. The franchisor has a business system or format which is identified by a trademark or a brand name. Third, the franchisee makes substantial capital investment and normally owns the business operation itself. 4, the franchisor trains the franchisee to ensure it is equipped to comply with the business systems. This is absolutely important in the sense of a franchise. 5, once the franchisee business starts, there has to be support from the franchisor. This ensures quality standards, because without quality standards, the franchisor may lose the goodwill and reputation in the market itself, which will act to the franchisor's detriment. Lastly, royalties. Royalties have to be paid by the licensee to the licensor. Why a franchise? Now, this is from the perspective of a franchisor. Lynn did touch upon it, so I will go through this very quickly. The franchisor is able to widen its presence to territories which may otherwise be outside the scope of his business. This could perhaps be because there is a home market saturation, or because he wants to explore new areas. Such expansion is possible with limited financial investment. Franchising is also a means to raise capital and expand quickly. This is also, to explain this a little more, because the franchisee puts the capital investment, the franchisor does not have to do that. Finally, there is profit and growth of the brand. Royalty license fees are received by the licensor, and the franchisor's trademark gets more visibility in areas which he would have otherwise not concentrated on. Why a franchise? From the perspective of a franchisee. The franchisee is able to take advantage of the goodwill and reputation owned by the franchisor. So a consumer kind of knows what is the quality of the or the standard of the product that is available, or the services that he can probably expect. For example, when you go to a Subway store, you know what exactly to expect, whether it is in Delhi, Mumbai, or New York. How does it matter? The look and feel of the store will still be the same. It eliminates risks of unnecessary expenses. The franchisor often provides support, both pre-opening and otherwise, including site selections, design and construction. Since the franchisee, a business is up and running in other jurisdictions, there are no surprises that are sprung. So therefore, the franchisor and the franchisee know exactly how to handle a difficult situation, therefore reducing the risk of failure. Franchising requirements. Now, franchising requirements, as explained earlier, the term franchise is not defined in the Act. However, permitted use is defined, and that permitted use is defined vis-a-vis registered trademarks only. So does that mean that unregistered trademarks cannot be licensed? It can be. The Act indicates the requirements vis-a-vis use by the registered proprietor or the registered user and other than the registered user. Now, I will deal with this bit in my next slide, but just to add a little bit to the unregistered trademarks, there are reported cases that have happened in India where licensors' rights were attempted to be usurped by the licensee after termination of the license. The licensee claimed that the trademark is his. There is no goodwill and reputation that the licensor owned in India. So therefore, obviously, because the licensor had given a license to the licensee, and in such cases, courts have given value to the signed agreement between the parties. So, therefore, the inference that I draw is that license vis-a-vis unregistered trademarks is also possible. Now, the use of a registered trademark by a registered user or an unregistered user is governed by the Trademarks Act. The Act categorically states that permitted use of a trademark inures to the benefit of the registered proprietor. This is given in section 48(2) of the Act. So the essentials that are given under the Act itself state that the agreement must be in writing between between the parties. However, irrespective of what applies for a registered trademark, I would say use the same principles for unregistered trademarks as well. The use by the licensee must comply with the conditions, limitations of the registration. That is, if the registration is subject to a limitation so as to color or jurisdiction, the licensee's use should also be restricted to those limitations. And the agreement itself must include whether the licensee is the exclusive user or the non-exclusive user, the degree of control the licensor will have over the use, conditions or restrictions, and period of the agreement. The license can be for an unlimited period. However, as a lawyer, advising a licensor, limited period licenses are always better. Now, coming to due diligence. Lynn did talk about it again. That was in the future, which already happened. Now, know your licensee. This is absolutely important, because if you do not know your licensee, he is the keeper of your goodwill and reputation in the jurisdiction that you have given the license for. So if he does not deliver quality or does not keep your standard, he's going to squander your goodwill and reputation. So know your licensee. Check the rights of the licensor itself. See if he actually has a registration, does not have a registration. The licensee must also check for third-party rights. So when you start off a new business, you don't want to start off on the back foot and say, well, I have been slapped with a infringement suit because this particular trademark that I have licensed from the licensor infringes an ex parte's trademark. Track record of the licensor must be checked, meaning whereby check the previous licenses that he's given, see how he supports them. Agreement must be in writing, registered or unregistered trademarks. Know your obligations. Seek good legal and financial advice. You know where to go. Due diligence vis-a-vis agreements. This I've tried to cull out from various case laws that have happened in the Indian jurisprudence. So I have not tried to say that this particular bit comes from this case law, but this is the common sense that I get from most of the case laws. So these are mostly those cases where the licensee tried to usurp the rights of the licensor post-termination. So what actually saved the licensor's marks are, first, there was an acknowledgement of ownership of the mark. In the written agreement between the parties, there was a confidentiality clause. There was the use was to be strictly in accordance with the terms of the agreement. There was a clause that indicated that the use should inure to the benefit of the licensor. This is specifically true for a common law jurisdiction like ours. When, like I mentioned earlier, licensing of an unregistered trademark is also possible. Then there were clauses which said categorically that goodwill will be owned by the licensor irrespective of the use by the licensee. Quality control checks were there. Duties of the franchisor and the duty of the franchisee was clearly spelled out in the agreement. Termination periods were spelled out, and post-termination obligations were clearly established. Pitfalls of a license or a franchise. Under-reporting by franchisee business of their business revenues. This is common because the royalties they pay out depends largely on what the business actually earns. On the other hand, they may be an over-demanding franchisor. There are times when franchisors do not facilitate the requirement of supervision that has been specified in the agreement between the parties, and of course poorly documented franchise agreements. While there are no laws that govern the franchise business per se, These are the acts that one must look at and be mindful of when entering into a franchise agreement in India. The Contract Act, yes, everybody knows the Contract Act. The Competition Act should ensure that a franchise business does not create monopolies. Income Tax Act, royalties and franchise fee attracts income tax. Consumer Protection Act, remember from the franchisor's perspective, if there is quality issues, a consumer could sue you or the franchisee as well. Now, thank you.